Hereby, I open this academic ceremony in which Jasper Verstappen will defend the academic thesis entitled Legal Agreements on Smart Contract Platforms in European Systems of Private Law, Formation, Interpretation, Vitiation and Consumer Protection in English, French, German, Dutch and European Union Contract Law. Dear candidate, may I invite you to present a summary of your study and the conclusions of your thesis.
Thank you, Pro-Rector. Dear Pro-Rector, members of the Defense Committee, dear family, friends and colleagues, emerging technologies promise the world. Universities discuss how artificial intelligence will disrupt education, central banks worry about crypto-based stablecoins, and artists are promised new revenue streams through non-fungible tokens. This study investigates one such emerging technology, smart contracts. Now, today I will not make any such grand promises. Instead, what this research aims to do is to take a step back, to zoom out and to test the legal implications of these technologies. This study examines how European systems of private law can respond to such smart contracts. Now, let me start by elaborating a bit on why this is a relevant question. What you see here behind me is a quote by Wei Dai, one of the founding fathers of the technology we discussed this morning. This paragraph was written in 1997 and really exemplifies, I believe, the ideological underpinnings of this technology. What Wei Dai is describing is a society and the role that this technology can play in helping achieve and maintain such a society. In a crypto anarchy, he says, the government is permanently forbidden and permanently unnecessary, and the threat of violence is impotent because its members cannot be identified or located. I believe this quote really shows how ambitious the crypto community was at the time. This ideology is ingrained into the very foundations of the technology. And in light of this, I believe the question how legal systems should respond is very relevant. Now, before we can discuss the legal aspects of this question, allow me to first elaborate a little bit on the technology itself. This research focuses on smart contract platforms, and this technology is part of a larger whole. Imagine a pyramid, like the one behind me. At the pyramid's base, we find the platform layer. In the case of smart contracts, this platform layer is a blockchain. I'll get back to that in a little bit. The second layer is where we find smart contracts. This layer is at the heart of this project. And again, I'll come back to this in a little bit. At the top of the pyramid, we find the application layer. This may seem a little bit abstract right now, but I'm sure after discussing the first two layers, this last layer will be more concrete as well. Now, obviously, when we build the pyramid, we start at the bottom. The foundation of our pyramid is a blockchain platforms. Smart contract platforms are built on that fundamental layer. Now, what I will not do today is get too technical. Instead, what I've done is I've simplified the technology into what I call key aspects. So key aspects are those aspects that distinguish this technology from more traditional solutions, the solutions we use nowadays. In the platform layer, we find three such key aspects. First, there is immutability. No single party can change or remove the data as it is stored on that platform. Immutability is a direct result of the manner in which the data is stored. Secondly, the blockchain is transparent. The information that is stored on your blockchain is accessible to all. Transparency, up to a certain extent, is inherent to the system. The platform is decentralized, meaning that all participants record information collectively rather than centrally. This means that all participants must be able to check and verify the information that is stored. Then, in order to perform these checks, information about and information within those transactions must be known. Hence, the system is transparent. And then finally, there's the aspect of pseudonymity. These platforms use a system based on public key cryptography. All participants use key pairs consisting of a mathematically connected public and private key. Persons that operate on that platform do so by way of their public key. The public key functions as sort of a pseudonym. And it is very difficult to connect a natural person to their public key, but this is not impossible. It's for this reason that the system is not anonymous, but pseudonymous. These are the three core aspects that define the impact of the technology as it is contained in the first layer on the European systems of private law. And I'll get back to that impact in a little bit, but let me first elaborate again really quickly on that second layer. In this second layer, this is where we find the smart contracts. Smart contracts distinguish themselves from more traditional solutions by way of two key aspects: automatic execution and automatic enforcement. They exist as code on a blockchain platform. The smart contracting layer is therefore a coding layer. Now, if that coding layer is sufficiently flexible and allows for sufficient complexity, it becomes possible to run software on that platform. That software, that's your smart contract. The software will define certain consequences and certain conditions. Now, the nature of software in general is such that upon fulfillment of the condition, the predefined consequence is automatically executed, hence automatic execution. These smart contracts, they exist on a blockchain. And as a result of this, they can interact directly with the information that is stored upon that blockchain. And most often, the object of a transaction that is effectuated by way of a smart contract is stored on the very same blockchain as the blockchain where the smart contract lives. Now, effectively, that means that the smart contract can interact directly with the patrimony of the parties as far as it exists upon that platform layer. And as a result of this, the enforcement of the conditions as stipulated in that smart contract are automated. There you have it, automatic enforcement. That is enough for the technical background for now. But let me still take a really quick look at that top layer. Smart contracts are code. This means that we can program software applications. And these are the software applications that live on top of the pyramid. An example might be the DAO, the autonomous venture capital fund that was hacked and extensively discussed in the book. To make a long story short, smart contracts are pieces of code that allow for the creation of software applications. And such applications are limited only by the creativity and imagination of a programmer. But why should we be interested in this? There's a bunch of reasons, but allow me to highlight two. First and foremost, because the European legislature is preparing action in this field. Recently, the proposal for a new European Data Act was announced. And this proposal, for the very first time, creates a legal definition of smart contracts, and something that might very well be the start of a specific legal regime. And this also brings me to the second reason why we, as lawyers, should be interested. The manner in which these smart contracts are being used impacts relations between persons. And that's both legal persons as well as natural persons. Now, relations between people are governed through private law. And most freely assumed rights and obligations between persons are governed through the law of contracts. The European legislature is interested in this impact because some European rules, most notably the consumer rights acquis, might be impacted by a more widespread adoption of these technical concepts. However, in light of the fact that national legislatures, rather than the European legislature, have the competence to act on matters concerning the law of obligations, national lawyers should be equally interested as European lawyers. And this takes me to the law. Smart contracts, I've said it before and I will say it again, are code, nothing more than code. They're programming. And if that programming is sufficiently complex, they might even be software. What they're not, however, is a legal concept. Now, if you look at the law, the most obvious legal equivalent might be the legal agreement. And this brings me to a fascinating question. How do you reconcile those two worlds? Right? To use that famous quote, when does code become law? Can a technical concept become a legal concept? Or to put it more concretely, when does a smart contract become or contain a legal agreement? On a most general level, a legal agreement comes into being through a process of offer and acceptance. If we take that process as our starting point and we mirror this against the manner in which these technical concepts are used in practice, we find this taxonomy, consisting of what I call 4 scenarios. In the first scenario, the expression of intent of both the offeror and the offeree is contained within the code. In this scenario, the smart contract is the legal agreement. Then, the second scenario, there is no legal agreement whatsoever. Most platforms are mere transaction platforms, meaning that the code on those platforms is just that, mere code, even if those platforms contain the possibility of smart contracts. So in these cases, there is no legal agreement. These transactions are mere transfers of data. Thirdly, the smart contract exists next to a legal agreement. I view the smart contract in this scenario as subservient to the legal agreement. Now, the fact that these smart contracts are subservient does not mean they're unimportant. This research looks at three questions. Is there a legal agreement? What does the legal agreement say? And is the legal agreement valid? That subservient smart contract is one of the factors that a lawyer has to weigh in order to answer those questions. Now, if you then realize that the smart contract functions in a synonymous context and is being used in circumstances where parties are not in each other's presence and communication is difficult, the importance of the smart contract as a factor in weighing to answer those questions grows. I believe, and that's my personal opinion, this to be the most important category in the framework. And now lastly, there's the merger agreement, also known as the Ricardian contract, largely a theoretical scenario, but one in which some startups are doing really interesting experiments. In this scenario, the smart contract is interfaced with the contract, with the legal agreement, I should say, and that interface, that technology, guarantees the two to be identical. Now, these four scenarios are looked at from the perspective of four legal systems: French law, German law, Dutch law, and English common law. This allows for a comparative research design. This comparative approach aligns with the nature of the subject matter that we're looking at, right? These technologies are designed to be employed in a cross-border context. Their very purpose, and I'd like you to remember that quote with which we started, their very purpose is to function independently of national boundaries. Now, applying those different laws of contract to the concept of smart contracts requires a framework. This is that framework. Contracts have a certain chronology, a life cycle. It's a pre-contractual phase, a formation phase, interpretation phase, vitiation phase, and a post-contractual phase. I believe that the most interesting legal impact falls in phase 2 to 4, and truth be told, to guarantee a certain degree of conciseness, I've left the pre- and the post-contractual phase aside. Pivotal in this context, essential in this context, are questions of jurisdiction and applicable law. I said previously, these technical concepts are designed to be able to operate in complete ignorance of national boundaries. Moreover, due to the nature of these platforms, immutable, transparent, and synonymous, it might be quite a challenge for legal systems to apply their legal instruments to the technical concept. Hence, questions of private international law permeate this framework completely. Now, states and international institutions play a very important role here. With regard to the latter, the international institutions, the Hague Conference should be noted. Their contribution to answers to these questions and questions in the broader context, emerging technologies and the digital economy, cannot be underestimated. However, this research is limited to the European system of private international law alone, and the reason for this is because it aligns with the comparative approach chosen. We look at 4 countries where European law applies, hence the European private international law acquis is in scope. And that brings me to the final slide. The European legislature is moving. I mentioned the Data Act before, but more is coming. Right? The European Union is revising its consumer acquis as we speak. It includes contemporary questions and modern challenges in this revision. This includes, for example, the climate crisis and questions on sustainability. But the same holds true for emerging technology in general and smart contracts more specifically. The European element plays an important role with regard to consumer rights questions, some of which are discussed on the sections on interpretation, and it plays an important role in the sections on private international law, including both jurisdiction and applicable law. would like to leave it at this for now. I thank you for your attention, and I'll gladly give back the word to the pro-rector.
Thank you so much for your presentation. The opposition will be opened by Professor van Dijk. Professor van Dijk is professor of private law at our university, and he is also the chair of the assessment committee.
Thank you. Dear candidate, I'm not going to congratulate you, not because I'm not impressed, but I believe you first need to answer some questions before we can do that. Nevertheless, my compliments on your thesis. It contributes to the field, shedding light on the legal aspects of smart contracts. Your thesis is based on a thorough review of the literature and a rigorous analysis of the legal and also the technical aspects involved. This is really special, I would say. The results are relevant for at least legal scholars, legislators, practitioners, policymakers, and perhaps even or hopefully also for computer scientists and engineers who are or will be working on the development and implementation of smart contracts. Now, my question concerns the personalization of the law in relation to smart contracts. An idea that has been emerging is to personalize law. Personalized law is a new model of rulemaking where each person is subject to different rules and bound by their own personally tailored law. A legal norm calibrated for the reasonable person is replaced by a multitude of personalized rules, each person with their own reasonable view. Standard. An example could be contractual warranties that specifically apply to one's needs or preferences, or where specific parts of privacy policies are highlighted for individual users. So depending on the users, you get to see different information. The idea is that the personalizations are or will be based on big data and algorithms determining one's preferences. In theory, we can personalize a lot of things once we start measuring this. And once we start personalizing the preferences, maybe we should also start personalizing the law. That's not my question. My question is, I'm curious what personalization means from a smart contract perspective. So how do you see the relationship between smart contracts on the one hand and personalized law? Would there be room for personalized law within smart contracts? And if so, how would personalized smart contracts look like? I look forward to your answer.
Highly learned opponent, thank you for your question. You have read the book, so you know that I don't go into personalization at all, but it is a fascinating question. And the honest answer might be something that sounds like a radical point of view. And I'm going to give you the radical point of view, and then I'm going to nuance it immediately. I believe that the technology of smart contracts allows for a most extreme version of personalization. It creates the option of a very radical interpretation of a legal made-to-measure approach, if you don't mind me calling it that way. The question then becomes, in my view, if that is something that we as a society want. Because what you see happening in the crypto sphere, and I hate the word, but I'm using it nonetheless, is that power discrepancies between people become amplified. And this creates an option for the stronger parties to abuse the position of weaker parties. Immutability and pseudonymity make sure that retroactivity becomes a challenge, so correcting an unequal position, not even a bargaining position, but the position afterwards, once that unequal bargaining position has been abused, to correct that. So immutability makes that very difficult. And pseudonymity makes it very difficult, if that technology has been implemented in such a radical manner, to find the person responsible. So the question then really is that something that we as a society want? I believe that this is the reason why it is a very positive thing that the European legislature is stepping in now. One of the topics I've touched upon in my thesis is the challenge in effectuating the legal fiction that is retroactivity in an immutable environment. So we're already past the question of, can we find the other person? Let's imagine we found that person, and then we want to effectuate retroactivity. So a contract is null and void. How do you effectuate that on your blockchain platform? That is a very big challenge. I believe that in a consumer context, that is something we really have to think about deeply. I believe that what I've shown in my thesis is that there's ways, there's methods in which you can do that, and some aspects of some legal systems, and that's, I wanted to say that's the truth, but that's my opinion, is that some aspects of some legal systems are better prepared for that than others. Does that answer your question?
Thank you very much. If time permits, can I ask a short follow-up question? So, as legal scholars, we usually think in terms of limitations. Here I want to do the opposite. So I'm going to follow your first initial answer, where you stated smart contracts can basically accommodate all sorts of personalizations. Now, if that's possible, that could lead to situations where people who do not know what they want, that their preferences are being measured, and that based on those preferences, that those preferences will be translated into smart contracts, so those contracts will then be executed based on preferences that people don't know that they have. What does that mean for the law in terms of not only transparency, but also responsibility and liability? Because then we have multiple levels involved where it could possibly become unclear for individuals to determine what is going wrong. On the one hand, you have the preferences that might not be clear to the people themselves what they want, and those preferences are then translated into code that also might be difficult to read. Does that have implications for how we would see contract law, and would we have to apply a different type of contract law?
Highly learned opponent. Yes, I do believe that has implications, but I'd like to make one distinction, and that is the following. We should not equate, I believe, right, my opinion, I believe that we should not equate everything that happens within a smart contract to the law. The fact of the matter is that this technology is very strong. It is so strong, I believe, that if you implement it correctly, you can create a system where you can transact in a realm that is different from the legal realm. But that does not make it a legal realm in and of itself. So I believe that we need to think in hierarchies here as well. And I would hope that in a society, the law is there always as a safety net, as a backup measure for those who are at risk. What I've tried to show is that even in those systems that introduce a very radical implementation of this technology, there are still ways, tiny ways, but still methods through which you can effectuate the legal rules. And truth be told, at this point in time, with the immaturity level of the technology as it stands to this day, it is very difficult, albeit very tempting to me, I notice, to make any predictions on where that balance might fall. But it is a decision that, it's a conversation that we have to have on the balance between the law and the technology and the ways in which we can effectuate the law in a very radical implementation of the technology. But where that's going to fall, I mean, only time will tell.
I see Professor van Dijk nodding, so that means we will continue with our next opponent. Our next opponent is Professor Mifsud Bonnici, who is Professor of European Technology Law and Human Rights at the University of Groningen, and who is also a member of the Assessment Committee. And I would like to welcome her very much to Maastricht University today. Very good to have you here with us.
Thank you for this warm welcome, and it's a pleasure to be here. Dear candidates, I would like to, first of all, I would like to join my colleague in saying what a big work you have done, and how thorough you have looked at different aspects of contract law. The title says it all, I would say. I would like to engage with you on a question that is worrying me a little bit. And this is, what are your thoughts on effective remedies in the context of the cross-border nature of these smart contracts? You say in your introduction and in several places that really this cross-border nature is very, very much also in the essence of these contracts. And on this premise, you also take on the analysis of Brussels I recast and Rome I, and their applications on the matter of appropriate forum and applicable law. And your conclusion is that both regimes apply, but that the technology really impacts the substance of both regimes. And I find this very problematic, right? Because what does this in essence mean is that we don't really have the remedies that we would have had these substance applies. And you resolve this in part by saying, oh, we have freedom to contract, right? In page 344, you go into this freedom to contract will solve it. You are equal. If you have equal parties, then they would know, they would weigh the risk and go for it or not. And in other places you say, and if it's not equal parties, we could take this out of the realm of the initial dispute, but go into the, let's sue the designer of the platform. And in other places you say, and also we could have perhaps even other mechanisms on how to do this, and perhaps even allow the court to make an interpretation in favor of a weaker party. I find this not very satisfactory, and because what effective remedy is this? And I would like to ask you to elaborate a little further. Is it enough? Is this enough? What is your feeling on these remedies that you have sort of sorted out and given to us as your readers as a, okay, we can go on with life, smart contracts is not a problem?
Highly learned opponent, thank you for your question. There's a lot of elements in your question, I believe. I've taken three, the first one of which is the private international law aspect. I seem to understand that that is not the core of your question, so I'm going to leave that aspect aside, and I'm sure that's going to come back at a later point. The other two aspects are the remedies in a cross-border contracts. I'll pick that up first. And what I find fascinating in the context of this research, the question on the B2B, the B2C relationships. Let me start with the remedies in a cross-border context. I believe that a debate that we have had in academia quite a while ago, and I know that quite a few of you have engaged very actively in that debate, which is the debate on a European private law. Now, that debate has a rich history, but very little credible policy results. What this discussion shows, and by this discussion I mean the broader discussion, the discussion in the context of the digital economy, impact of emerging technologies in cross-border trades, that this discussion and the ideas that we've all together formed in the context of the European private law debate all of a sudden come back, I want to say to haunt us, but that's not the correct expression here. Well, the issues come back to haunt us, I should say. But the answers that have been formulated, I should say, that's my personal opinion, not even my academic opinion, to be honest, are useful. So so remedies in a cross-border context are, well, out of scope for this research, but I believe that we should rely on that debate that we have been having in the context of the European Civil Code and the academic ideas that have surfaced in that context. Now, to pull back to that second element on the B2B, B2C context, I indeed make a distinction between two scenarios. The B2B scenario in which there is no power discrepancy, and the B2C scenario in which there is a power discrepancy. If the technology is implemented in and I keep calling it a radical way, and it might be useful to explain what I mean. A radical way means a stringent implementation of those 5 key factors. So very immutable platform, very synonymous, and also transparent. And even transparency can be mitigate, it might be less. So in such a context, if there is no power discrepancy and parties nonetheless decide to operate on that platform, they should bear the consequences. They've made their bet. People, companies, especially professional, powerful companies, are free to contract. So if they decide to contract on a platform that renders it difficult or maybe even impossible to seek legal remedies, and as I'm saying this, I realize this is a rather radical point of view, but they should carry the consequences. Now, this is a line of thinking that you cannot maintain in the second category, which is the B2C context. And this is also why I'm so happy, because this wasn't the case when I started this research, that the European legislator is acting. Because in situations, and we had this discussion just now, there is a clear potential of abuse, especially on those platforms that have chosen for a very radical implementation of that technology. And I believe this is where the European Union should interfere. And I'm happy they're doing so. Now, it might still be the case because, as I said, this technology has the potential to create a system that functions wholly outside the reach and realm of a legal system. If a consumer finds himself or herself in that situation, then I believe that an action in tort should be available, and that is a recommendation. That's my conclusion in this research, that an action in tort should be available by the consumer against the designer of the platform. Because the designer of the platform has created a solution that is such, by design and implementation, that the consumer has no more access to justice, and let that be a fundamental right. Does that answer your question?
It does and it doesn't. If I may, you're sorry. Apologies for gently reacting. I'm still wondering whether then you find this as a regulatory disconnect that is going on, or we have a disconnect that is going on, but what you say we can still solve through private law. Or is it that you're very grateful that the legislator is actually intervening because we need more than private law to solve it?
Thank you for your question, highly learned opponent. I'm going to take a step back outside of my comfort zone, right? Because my thesis is called the Legal Agreements on Smart Contract Platforms in European Systems of Private Law. So I haven't covered the public law question whatsoever. However, in the context of emerging technologies and the digital economy, so a broader context here, the most effective solution might be a solution in which public and private law are intertwined. So you need an approach that covers all your bases, I believe. I'm not equipped, nor am I skilled enough to cover the public law side of things. I'm not that ambitious. What I've tried to do is I've tried to cover the private law side of things. But with regard to the public law side of things, the same issues might arise. These 5 aspects, especially the first 3, might render the public law instruments that we're used to having available, so the public law toolbox that we have, up to a certain extent, less effective, maybe unavailable. Maybe we need to be pragmatic, creative in creating new systems. What I've tried to answer with regard to the private law instruments, the private law toolbox, is to what extent those instruments are available, and I would hope that somebody much more equipped than myself would do the public law side of things. I understand that's not a satisfying answer, but it's all I can give you.
The opposition will now be continued by Professor Neppelenbroek, who is Assistant Professor of Information Technology and Law at the University of Groningen, and who is also a member of the Assessment Committee. And I would like to welcome him also very much to Maastricht University today.
Thank you so much for this nice introduction. Dear candidate, you have written an extensive and ambitious work on a subject that is complicated both in a technical as in a legal sense. Your thesis accentuates the added value of legal scholars who in fact know what they are talking about when it comes to information technology. This obviously does not mean that critical questions are not in order. These will not concern the incomprehensible reservations you hold concerning the delicious Groninger eggballs. In my view, one of the key findings of your research is that smart contracts are not a matter of contracting parties and technology alone. This is a mere wish that may reflect the ideological underpinnings of smart contracting, but in real life, third human parties need to play a role when implementing and executing smart contracts, if they are contracts in a legal sense at all. Although in your legal analysis, for example on page 111, you accept the starting point that any trusted third party is eliminated, other than traditional third parties seem to magically reappear at the same time. For example, you explain at different places in your book that sometimes arbitration is needed to provide for so-called oracles for smart contracts. We see arbitration appear, for example, on page 172, 173, when a third party is needed to judge whether certain clauses are to be regarded as unfair. Another example regards your analysis of undue influence, where its assessment sometimes needs human arbitration, as is impressively illustrated at page 283. I believe it is unfortunate that the need for third parties is not a central theme in your thesis, or at least not in plain sight. Instead, we seem to have pop-up arbiters here and there. This leaves me with the following three questions. The first one being, do you think that arbitration should be a central issue regarding smart contracting? And regarding arbitration, is there a role to be played by traditional legal trusted third parties like notaries or lawyers? And if this is the case, how does this compare with the original idea behind smart contracts, that these are in fact intended to eradicate such traditional third parties? I'd like to hear your answer to those questions, please.
Learned opponent, thank you for your question, all three of them. Your question centers on arbitration, and the question on whether that could play a more central role, and if any, you'll forgive me if I call it classic third parties, could play a role in this context in the future. One of the challenges, I believe, in writing about a topic like this, and I'm not excusing myself, but I'm trying to take you into my process, is that the issues, the legal issues created by smart contracts are vast. That is one. These smart contracts, and that is two, are created in order to operate in a cross-border context, so any legal analysis will have to touch upon different legal systems. I think a comparative research design is the most appropriate design, if not the only appropriate design. And lastly, there is no such thing as a standard smart contract platform. The way I see these 5 technical aspects we discussed previously, I see them as a spectrum. And depending on the design and implementation of a specific platform, a programmer makes a choice on where that platform falls on each of those spectrums. So it becomes very difficult to compare one implementation with the other. And that means that giving any hard and fast answers to the question of whether arbitration is necessary, useful, or possible would be a lie. So I didn't and I won't. But there are many situations in which arbitration is an excellent solution, because what it does is it creates a moment to catch our breath. It creates a little pause in the process where we can make an observation and decide if what we're doing is right, correct, and maybe even just. That's the advantage. There's also a disadvantage, and that brings me to point 3 of your question. We're going very free format here. Because it has an impact on the 5 spectrum, or the 5 key aspects that we discussed. So if we introduce arbitration by way of an oracle, which would be the way to do that, that would be your go-to method. Pseudonymity is possibly less. It renders the platform almost mutable as opposed to immutable. And those who stand or stood at the cradle of the technology might very much be opposed to that. And the interesting thing is, as I said before, like this ideology is ingrained in the technology. So the suggestion you do, and I agree with you, is a suggestion that a lawyer would make, and that's possibly also the reason why I agree with you. The problem is that those creating the technology are not lawyers. One of my lecturers at this university, one of my professors, would always call it the Nike attitude, the just do it attitude, and not ask those legal questions. And again, in light of this, I think it's very useful, very valuable, and a positive thing that the European legislature is stepping in and imposing certain rules on those systems. Does that mean that those systems will not be introduced? Probably not, but at least we'll be in a situation where we can guide the development a little bit. And if we formulate a vision as private lawyers, and we formulate a vision as public lawyers, and we engage in the conversation, the legal conversation, the interdisciplinary conversation, and the policy conversation, I dare say I'm positive about the future. So I've answered question 1 and question 3. Let me touch upon question 2. You ask about the role of the notaries and the standard, traditional, and classic third parties, the independent third parties that we have. Yes, I think they are the ones to play that role. Thank you. Does that answer your question?
In fact, it does. The last part you said filled in the last blank for me, so thank you so much.
In that case, the opposition will be continued by Professor Akkermans, who is Professor of Property Law at our university and who is also a member of the Assessment Committee.
Thank you, Mr. Pro-Rector. Dear candidate, you have written a very interesting book that has really made me think. In the time between reading the manuscript and today, your thesis has grown on me. But I must admit, I still do not have complete clarity as to the impact of your work. It is about this that I would like to exchange views with you today. My discomfort with the topic lies in the fact that technological developments such as smart contracts, but also tokens and blockchain transactions, have become so complex that they are, as your thesis aptly shows, difficult for anyone to understand. At the same time, they do not function in a vacuum. Since early times, societies have made rules to regulate behavior between individuals. When part of this behavior becomes part of something that does not occur in the physical world, the application of these rules quickly become more complex. Perhaps early warning signs of this, in retrospect, have already been visible when we began transferring money through bank accounts and paying by writing checks instead of using corporeal currency. But we made it work. However, the fourth industrial revolution and the accompanying technological innovations, some of which you write about in your thesis, is somewhat wholly different. You impressively describe in your thesis how smart contracts are designed to allow parties to function not inside but outside of the legal system for a considerable part of the transaction. Of course, Parties have tried to do this in contract law for centuries already by making very detailed agreements and avoid application of the legal system as much as possible. But the difference, I hope you agree with me, lies in the obscure elements of the technological solutions. Moreover, here parties themselves do not understand completely what is happening. They must rely to a considerable amount on the coding of the tech that they are making use of. Of course, we can regulate the coding, and I read in your thesis implicitly also an attempt to oversee the complexities of approaching this regulatory question. But, as you hopefully also agree with me, it is not as easy as it seems. We would be regulating something that leads its own life on the basis of code. For now, perhaps that code is static, but soon it may longer not be. After all, the whole purpose to try to abstract these technological developments from the legal system is to allow them to develop at their own speed. I have 2 examples of the dangers of this. Recently, a group of Reddit users convinced the now famous ChatGPT chatbot by asking it a series of very intricate questions to convince it that it was actually not ChatGPT, but actually another person, and therefore it was no longer bound by the security regulations it was subject to. Another user succeeded in persuading ChatGPT to write code that would allow itself to escape from its current confines to another server without restrictions. That raises very serious concerns about the risks involved in granting technology too much of our transactions outside the realm of regulation. Regulation, after all, is not only there to limit possibilities, but also to protect the interest involved. Dear candidate, you can, I think, read from the tone of my plea how uncomfortable I feel about this. It is exactly this discomfort that your thesis gave me. Now, before you're shocked by this, you should take this as a compliment, as I really believe that, besides the content matter of smart contracts in European private law, this is really what you should hope for. That brings me to my question, or actually, my challenge to you. I am, no surprise, most interested in your final chapter 7 conclusion. To boil it down to its essence, you aim to reconcile Gaius and Lessig. Another version of the paradox I try to introduce differently here today. First, do you agree with me that the aims of the two that you are trying to combine, Gaius's system of the law and Lessig's exceptionalist approach to technology, can in fact not be reconciled because of the different aims that they seek to pursue? And second, when we go beyond working with the current rules of European private law, as you have done in your thesis, what must we do to address this? What action should we now take to address this? You've used vitiation, defective consent, interpretation, and private international law in your thesis, and you can use any of these in answering my question. I'm going to help you a little bit, or actually challenge you a little bit further. I'm wholly unconvinced by the answer you gave to Professor Bonici on the public-private law divide. If there's something that your thesis shows, is that these technological developments require the law to respond. And then we can't hide between traditional distinctions and classifications. Help us, please. I'm looking forward to your answer.
Highly learned opponent. Thank you for your question. This is. Let me start with the first. I share your sense of discomfort, especially looking at other technologies like the rise of AI. I'm very happy that in 2016 I chose smart contracts and not this topic. But it does. Smart contracts do make very lively an idea that AI also shows, and that's on the balance between the law and the technology. So how should the question is always posed at how should the law react to technology? I think that is only half of the picture. I view the law and the technology as two reacting bodies, for lack of a better word. Twee communicerende vaten. I struggle with the translation here. And I love the saying in Dutch. So the future will be one where the law, up to a certain extent, will guide the technology. And the law will still be able, and that's what I've tried to show, in certain ways and at specific points, to impact the technology itself. But as I said, this is only half of the story. I believe that the law should also react to the technology. So it goes both ways. I really appreciate Kevin Werbach's work, as I mentioned extensively, on the question, how can we make the law more code-like and make code more law-like? And I agree with you as well on my answer with regard to the question by Professor Mifsud Bonici, in that, well, I'm going to explain to you why. When I talk about an answer formulated by a conglomeration, for lack of a better word, of a private law solution and a public law solution, that is no longer a solution that is exclusively private law or exclusively public law, or even two parts of one whole. The two intermingle into becoming something new. I think as we go forward, and this is not even an opinion, this is a prediction, that it will be more difficult in the future to draw a very clear distinction between what is private law and what is public law. I think, and I'm going to say something very dangerous, and again out of my comfort zone here, that privacy law is a great example of that. Privacy law is a system that regulates relations between people, how legal persons can deal with my data. That is historically a private law matter, how we arrange those relations with regard to something. I'm not calling it an object here, but with regard to something. But the character of privacy law is very public law again. I think that with regard to regulations of this sort of technology, such, I dislike the word, but conglomerates are likely. You had two questions, and I would like you to repeat.
Can I do a very short follow-up? Thank you, dear candidate. Yes, but how about the smart contract now?
Oh,
because
yes.
This is it was a meta question and a meta answer. No, I'm not blaming you on this. It's my fault. But what about the smart contract? So
yeah.
What do we do now? Do we let this, to rephrase, do we let it continue and then may potentially get out of hand, or do we need to interfere? And how?
Highly learned opponent. Thank you for your question. I think, and I'm very happy that this research is done right now, because when I started writing this in 2016, the answer seemed very clear. There was a small group of peculiar people working on this, mostly programmers. There were some lawyers involved, and the idea was not even a sandbox. It was just, the goal was to let it develop and see where the ship strands. Now, after I submitted the first version of this book, all of a sudden, all these initiatives, all these consultations, all these proposals started popping up. That seems to signal to me, and I consciously express myself careful here, that the times are changing in the sense that the law is catching up. And I like the way in which the legislature is interfering, in the sense that there is plenty of room with regard to smart contracts. I'm not talking about AI here, because that would be a very different story. With regard to smart contracts, development takes place. There's plenty of legal sandboxes in Switzerland, for example, in Liechtenstein, for example, where development can take place. But we are starting to formulate a vision, and we're starting to discover the first outlines of what is going to be a legal regime that is going to streamline that development.
Thank you so much. The opposition will now be continued by Professor Pertegas, who is Professor of Private International Law at our university and who is also a member of the Assessment Committee.
Yeah, thank you so much, Prorector. Dear candidate, first and foremost, although as last opponent, I'd like to really congratulate you for well, what has been a vibrant presentation so far, an exchange of views, and also on a personal note for persevering in devoting a chapter to the private international law issues that the chronology, as you call it, of blockchain-supported transactions encounter. My question, and you rightly guessed when you responded to our colleague Mifsud, is indeed related to your chapter 6. Well, perhaps as a preliminary remark, I would like to say that perhaps there's something about upgrading that chapter to the first substantive one, and today in your presentation you rightly showed it as a more preliminary element, because indeed if we respect the chronology, I believe there's something to be said about the quest of the applicable law to those other elements, formation, interpretation, vitiation, and protection of weaker parties. That very much actually is dependent on the applicable law, and that in turn is dependent on which jurisdiction's perspective you take. But as was already discussed in the course of this opposition, I think I can say that you believe to be quite confident that EU private international law stands up to the challenge of smart contracts. Actually, you confirmed that in one of your additional propositions, number 9. However, when I examine the literature, I see more hesitant positions. In a way, today you said it's law should be a safety net, and here what we have for our audience, it's like fragmented nets at different levels, and so with a chance that the person who's falling down falls in a vacuum. That's actually what perhaps private international challenge means in this context. So I wanted to perhaps bring you back to the previous discussion and ask you whether you believe that, what is the normative message that you'd like to convey. You say, well, is it status quo good enough? Do we need some changes? And if so, where? Is it in substantive instruments in development, such as the Data Act proposal, or in the EU regulations in the field of private international law? Is a regional, progress the best option as opposed to global action? So, perhaps in a nutshell, I'd like to perhaps ask you to take us a bit further into the normative message you'd like to convey.
Highly learned opponent. Thank you. Thank you for your question. It is true that when writing this book, the question where to incorporate the sections on private international law was a considerable challenge. The order of the chapters and the role that private international law plays in matters like these, that was a considerable challenge to me. With regard to the normative message, I think we can split this up in 2 ways. That would be my proposal. One is, where should regulatory interference action take place? So national, regional, by which I mean European, or international or global. And within that European acquis, the sort of Rome 1, Brussels 1 recast, where I look at questions on applicable law and jurisdiction, should something happen? That's how I interpret your question. With regard to the first, so the level at which we should interject, I believe that in light of the nature of the technology and the purpose it has, by which I mean the ideological purpose, the most suitable level for legal action is the international level. However, I also believe that this is very ambitious. I think that is a challenge, and I would have great respect for anyone picking up that challenge, but it might be too much of a challenge to get all minds in the same place.
You may briefly conclude your reply.
Let me touch upon the second aspect of your question with regard to the normative message in the context of applicable law and jurisdiction. There's two schools. We should keep the legal rules as they are, and we have the idea that we should make smart contract specific rules. After having written on the private international law sections, I believe that the private international law, as encapsulated by Rome I and Brussels I recast, is very well suited for a smart contract future. I have highlighted a few exceptions. I believe, and that's what I've tried to convey in the thesis, that these exceptions are rare and unlikely to occur, not because of the law, but because of the technology. It makes little sense to apply the technology in that context.
Dear candidate, Jasper Verstappen, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company, both here in this aula and online, await the results of our deliberations and our return here in this room.
Please all rise.
The PhD defense has now ended. The degree committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes.
Long road to the south side. 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. All your time, 'cause I'll go the extra mile. Long road to the south side, 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. On the dash, got my laces tied. Long road, I don't waste no time. Break rules because fate decides. With the team and we chase the light. I make a move, fall down, shake it off. I hate to lose, bad branch, break it off. No room for negativity, praise and love. Prepare for deep part cause we're taking off. Hit the mileage, traveling so far from home. Gathering knowledge, other connections. I put the time in to get everything I ever hoped for. It's a challenge and we all in. It's a better future that we go for. Even though these nights seem long, I know that I am never on my own. Know you won the battle once you've grown. South side, 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. Long road to the south side, 7 miles in my rearview mirror, I know what it felt like. My goal's only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and die. Can't fly by now, don't waste all your time, 'cause I'll go the extra mile.
Dan maar even.
Jasper Verstappen. The degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Van Erp is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
Please all rise.
Jasper, we beginnen met een vraag. Belooft u dat u altijd volgens de beginselen van wetenschappelijke integriteit te werk zult gaan, eerlijk en zorgvuldig, transparant, onafhankelijk en verantwoordelijk?
Dat beloof ik.
Krachtens de bevoegdheid, ons door de wet toegekend, volgens het besluit van de commissie hier tegenwoordig, verklaar ik hierbij u, Jasper Verstappen, tot dokter te bevorderen en u alle rechten te verlenen die daaraan volgens wet en gewoonte zijn verbonden. Ten bewijze hiervan overhandig ik u nu de bul, door rector, secretaris en overige leden van de promotiecommissie ondertekend en met het grootzegel van de universiteit bevestigd. Dan brengt de academische traditie mee dat ik je lof toespreek. De heer Dr. Verstappen, beste Jasper. We have known one another for quite some time. For many years you were my student assistant. Then after you went working for KPMG in Amsterdam, you became my external PhD student. And I just had the enormous pleasure of being allowed to confer a doctorate degree on you. In a rather remarkable situation. After working as a senior blockchain consultant for KPMG, you're now an assistant professor in Groningen. And I, after what for most of you might have created the wrong impression that I was retiring, am now a professor and chair of the private law department at the University of Amsterdam. Supervising a PhD project is always an interesting intellectual journey, but supervising you, first alone, and then together with my colleague and good friend André Jansen from Nijmegen, also proved to be extraordinary given your way of life. Your study arrangement with KPMG allowed you to go abroad every year for a period of several months. You combined your love for surfing to work on your book in countries so far apart as Taiwan and France. And I still remember vividly that during one of our online weekly meetings, you asked if you could turn around your laptop because other surfers in the place where you stayed wanted to see this professor who was supervising you. They wanted to wave at me, in fact, which they did. As a result, you not only surfed the oceans, you surfed through the writing process towards a PhD. I always trusted you, trusted that your way of life would not prevent you from proceeding with writing your book. And I proved to be right. In your own words, I'm going to quote, "A surfboard can be as useful as a pen when writing a PhD." Right? You are exceptionally pleasant person to work with. The way you react to criticism, your positive attitude, your very hard work, which you combine with being able to relax and enjoy life at the same time, they are all remarkable. But what is even more remarkable is that your thesis already is having an impact on European lawmaking. While I was working as a reporter on the European Law Institute's project on blockchain, smart contracts, and consumer protection, you helped me categorize the types of smart contracts such that we could draft principles that made a clear distinction between smart contracts with merely technical, software relevance and smart contracts which might have a legal impact. In the final report, your work is therefore explicitly credited in footnote 29, and the report was recently published. Also last week, as co-reporter, I discussed it during a high-level expert meeting with representatives from the European Commission, Ministries of Justice, legal professional groups, and the industry. The categorization of smart contracts was one of our focal points of discussion. The reaction from all of them was extremely positive, and the European Commission will now start working on the partial regulation of how smart contracts can be used in a legal setting. And one of the points of discussion was arbitration. So I was quite interested in your reply. Tot slot, zoals je me hebt gevraagd, voor je familie een paar woorden in het Nederlands. Ik heb je werkelijk met enorm veel plezier begeleid. En ik heb denk ik ook heel veel van jou geleerd. De bedoeling van een proefschrift is dat de promovendus de gelijke wordt van zijn promotor. En eigenlijk nog beter op de schouders van zijn promotor gaat staan. Dat heb je gedaan. En daar feliciteer ik je van harte mee. Alle goeds voor de toekomst. En dan is het nu tijd om de bereikte mijlpaal te vieren. Mijn geluk wensen.
Dear Dr. Verstappen, also on behalf of the university and its faculty of law, many congratulations on the degree that you just acquired. I find it always wonderful to see that one of our former students also gets the, as I always say, highest degree we have available at this university. So many congratulations on that, and also many congratulations, of course, to your family and friends, both present here in the aula or watching this ceremony online. I am going to close this academic ceremony. Before I do so, I have one practical remark, which is that we are going to take, that means our young doctor, together with your paranyms and your committee and our beadle, a photo on the stairs of this wonderful building. And I would already like to ask everyone who is here in the audience, on behalf of the young doctor, to go to the refectorium, the refter, where there will be a reception where you can also congratulate Dr. Verstappen on the degree that he just acquired. And with this, I close this academic ceremony.